unable to appear before this court and end up in another court. Today I have already- Petitioner.
What is the latest salary slip?
My lords, the
How much is your
net salary
salary?
is 52,112.
Hmm.
My lords, the petitioner has got aged parents and he is also looking after his son, my lords.
Hmm.
So the trial court has granted 20,000
So you're getting 52,112.
Well,
What did you submit before this court when the matter came up for admission on the
That
date
is-
of first hearing?
my lords, before the trial court.
And
my-
counsel for the petition, the husband is getting salary of rupees 31,218. Is it not a false submission made before the
Lords,
court?
because that was produced before the honorable trial court, my lords, at the time of hearing of the IA for interim.
No, you have made a statement before the court.
Please, my lords.
Basing on that, an interim order is granted.
Lords, on the basis of the document produced before the honorable court, trial court, my lords, I have made the submission. Now, the recent salary certificate reveals that.
So you can pay 20,000. We'll dismiss it on the ground. Yes, please. Agreed with orders passed in. I number 2 and C miscellaneous number 91 of 2023. Dated 26/12/2023. The husband is before this court. The wife had filed an IA seeking interim maintenance. And considering the fact that his take-home salary is 31,218 and the net salary is 43,164, court had granted an amount of rupees 20,000. Agreed thereby the husband is before this court. On 3/7/2024, this court passed the following order, extract the order. And on the last occasion, this court has directed the husband to file the latest salary slip. By way of a memo, the latest salary slip is placed before the court. And as per the same, his gross pay is 60,350 and his net pay is 52,112. Which, looking at the salary, the income of the petitioner husband, the trial court had rightly granted 20,000 as maintenance, and this court finds no reasons to interfere. Dismissed.
Arrears of maintenance.
You have your own courts that in his petition, court will not tell all that. Yes, next.
Till number 3. Sorry, sir.
You that.
Okay, for the appellant in this matter, my lord.
Memo of
Lord,
retirement.
filed a memo seeking that I be permitted to retire from the.
Yes, filed the memo of retirement. Where is it? When was it served on him?
My lord, online shows that insufficient address, my lord.
Then,
This is the address that is there in the cost title also, my lord. I checked this online. It shows that it's insufficient address.
we will not permit you without that being served on you.
My
Poses
lord,
matter.
I don't have any, I only have the address that's
Poses
mentioned in the cost
matter
title.
After vacation. Yes. Next,
4. Shakti Deepak.
Serial number 4, my lord.
yes,
On it.
Respondent number 9 to 15 are, my lord. The sailing with the appellant, my lord. The notice may be kindly be dispensed with, because they are,
File a memo.
I file,
File a memo, then only it will be
so
dispensed with.
I'll file my mom.
No, please file a memo, then call the case.
Please.
Yes.
Bill number 5.
My lords, appearing for the appellant.
Onion KBS.
Yes.
My lords, in there are three connected appeals. In the first appeal, a translated copy of the interim order has already been furnished to the court. In the second appeal, my lord, since it derives out of the same interim order, I agree. It will file a dispensation application because the certified copies are attached in the first appeal.
Then you file the typed copies in this.
Yes, your lord, true copies have already been attached
Hmm.
in the second appeal.
Hmm.
My lord, the third appeal is again an incidental relief that was sought in terms of the first appeal. So regarding that,
No, look at the cause title. Office objection is kept open with regard to challenging IA number as per court order dated 11/6/2024. What is that?
my lords, if you have a look at the appeal,
MFA is filed against which order? First one, 2637.
2637 is on IA number 2,
Hmm.
my lords. And it is a common judgment on IA number 2 and IA number 5. So we filed two appeals for IA number 2, one for IA number 2, another appeal for IA number 5, another appeal for IA number 4, which was incidentally dismissed, my lord. My lord, this matter has already come up in the admission stage.
Oh, 11/6 order is, office objection is kept open. What is the office objection? Only, these are the office objections.
Yes, my lord.
The transfer appellant has challenged in IA number 4.
Since there is no court order on IA number 4, that is why the office has raised an objection. But the IA number 4, the relief sought in IA number 4 is incidental to IA number 2 and IA number 5. My lord, if you kindly look at the appeal, I'll just read out the relief.
No, let's look at the interim order, impugned order. Page number.
'24, my lords.
I'm looking at MFA number 2637.
2637. Yes, it's a
It's a common order.
It's a common order.
Yes, which
Yes.
page?
Page number 23, my lords.
It's in Kannada.
My lord, translated copy has also been filed.
Hmm.
So, my lord, if you have a look at the
Order on interim application numbers 2
2
and 5.
5. So the relief that was sought in IA number 2, my lords, was for restraining the defendants from carrying any construction activity and changing the nature of the suit. This was the relief sought in IA number 2. The relief sought in IA number 5, my lord.
But IA number 5, when it came to be heard by the court, it was not heard. This application is only IA number 2 and 5.
Yes, my lord.
4.
For since the relief is incidental, my lord, if you have a look at this thing.
There is. No, further, there should be a consideration by the court.
My lord, since it is an incidental relief arising out of the same suit, is why we had to file.
There
My
should
lord-
be an order. There should be an order by the court.
Yes, my lord, it's an incidental relief. Sorry. My lord, if you have a look at the prayers in the
Yes.
interim order, my lord, I'm looking at appeal number 2636 of 2024 at
Yes.
page number 52.
Hmm.
We've asked for in relief of temporary injunction directing defendants to demolish the structure.
Which case?
2636
Hmm.
at page 52.
Hmm.
Directing the defendants to demolish or put down the construction put up by the defendants in haste over the Schedule B property, despite the objections of the plaintiff and notice of the honorable
So,
court.
there should be consideration, there should be an order. Without an order, you cannot say that I can, okay, again, it's what an appeal and a miscellaneous appeal can be preferred.
My lord, one small submission. My lord, this relief, the interim order on IA number 2 and IA number 5 is regarding temporary injunction. And
That you can't file an appeal like that without an order saying that it is
my lord,
incidentally.
IA number 4 was dismissed incidentally by the trial court.
It was never felt for consideration before the court in the impugned order. It only speaks about IA number 5 and IA the other IA. If you look, please look at the order. From the order I am saying. If you understand something the more than what the court says, then on that an appeal can't be filed. Order on interim application number 2 and 5.
2 and 5.
That's it.
Yes, my lord. Okay.
What is it? So this office objection with regard to MFA number
2636 on IA number 4.
8 of 2024 is sustained.
My lord, 2638, no, 2636.
26?
36
Ah,
is on
26.
IA number 4.
The office
2636.
objections with regard to, in respect of MFA number 2636 of 2024 is sustained. Yes.
Yes, my lord. My lord, can we have it on the admission stage, my lord? The appeal.
Post this in MFA number 2637, the translated copy of the memo is filed. Post MFA 2637 and MFA 2638 of 2024 for admission.
Good.
Chair number 6. J. Krishna Bhatt, for 1 week time. my
Week's
God,
time.
Much obliged.
Default order.
Chair number 7. Ashish Krupakar.
If your lordships recollect.
My lord, I represent the petitioner, my lord. This writ petition has become infructuous.
Yes.
This was against the order dated, my lord, 24/9/21.
Mm.
There was an interim order of this honorable court, my lord, staying the order and permitting the respondent to celebrate the birthday of the minor child, my lord, for a few hours between 2:30 to 7:30 on 29/9. Now the said order has, my lord, rendered, this writ petition has rendered itself infructuous, my lord.
That's another petition, they had withdrawn in the chambers, if your lordships recollect.
That has no connection, my lord, to the facts of this case.
No, what is this order? No, let's understand from this order. What
My
is
lord,
it?
may I request your honor to turn to page 38, please, my lord.
38.
38, please.
Hmm.
My lord, this was an order passed on IA number 13, where the honorable family court, my lord, I may be permitted to take my lords to directly the operative part, which my lord will find at page number 40. IA number 13 filed under section 26. My lord finds it. IA number 13 filed under section 26 of HM Act, read with 151. Respondent is permitted to take the child from the residence of the petitioner to his custody at 6 p.m. on 28/9 and shall make arrangements to the child on 29/9 to attend online classes and also celebrate the birthday of the child, and shall hand over the child to the petitioner at 6 p.m. on 29/9 at her residence. Petitioner shall hand over the child to the respondent as per the order as aforesaid, and the petitioner is also entitled to join the respondent to celebrate the birthday of the child if she wishes to join. Against this order, my lord approached this honorable court. This honorable court on 24/9 was pleased to pass this order, my lord. Office objections are overruled. Issue emergent notice, interim order is pray for. The fair submission of the learned counsel for the petitioner that the respondent husband may take the child for a few hours for the celebration of its birthday, the ideal time being 2:30 to 7:30 with some flexibilities, and that she will cooperate in that is placed on record. My lord, based on this order for the last 2 years, my lord, the parties are celebrating the birthday of the child, which is on 29/9. Now, my lord, this order has rendered itself infructuous.
He wants to withdraw, then I'm okay, because the connected
No.
matter also he has withdrawn, because I filed an application.
My lord, it may be dismal, it may be closed as.
Let her submit, you have submitted, let her submit.
I filed an application before the family court to consider my application for overnight as granted earlier for the birthday.
Let the court consider.
Because of the interim order, the court is not taking that.
The agreed with the orders passed in I number 13 in MC number 3648 of 4/8 of 2018, the mother is before this court. I number 13 is filed by the father. And in that, the court had passed an order permitting the father to take the child from residence of the mother to his custody at 6 p.m. on 28/9/2021 and shall make arrangements to the child on 29/9/2021 to attend online classes and also celebrate birthday of the child and shall hand over the child to the petitioner to the mother at 6 p.m. on 29/9/2021 at her residence. It is also observed that the father shall hand over the child to the mother as per the order and is also entitled to join the wife celebrating the birthday of the child. If she was, the mother can also join the birthday celebration of the child if she wishes to join. Against that order, the present writ petition is filed. This court on 24/9/2021 interim order was granted. And the court observes that the fair submission of the counsel for the petitioner, that the respondent husband may take the child for a few hours for the celebration of its birthday, the ideal time being from 2:30 p.m. to 7:30 p.m. with some flexibilities, and that she will cooperate in that is based on record. Land counsel appearing for the mother submits that from the last 2 years, the father was celebrating the birthday of the child. And now literally this writ petition has become infructuous and no further orders requires to be passed in this writ petition. Accordingly, the writ petition is dismissed as infructuous.
Grateful, my lord.
Can trial court not be influenced?
No, I'm sorry, my lord, that's on a different footing.
Trial court not be influenced by this withdrawal because I filed an application.
I am not withdrawing, it has become infructuous.
There's no question of influence because court has not expressed anything on the merits of it.
Yeah, the question, that does not arise.
That extent also would be, the court is not expressing anything also would be, because then.
No, I am sorry, my lord.
That's his writ petition. He wants to withdraw.
Because the connected also is withdrawn and he is
Let
exercising.
him withdraw.
Grateful, no?
Yes, next. Respondent is here. No? Hmm. Hmm? Hmm. Right, Pratima appearing for the respondent. Yes,
My wakalat is there.
I think it's not
Yes,
reflecting, that's
yes,
what she's saying.
Till number 8, Hari Kumar C.
For the respondent in this case, only a 2 week short accommodation. He lives in.
Non-filing of wakalat. Why you are not filing wakalat?
Lord, he's staying in Australia, my lord. They have sent my lord. I have 100.
No representation for the petitioner at the request of land counsel, the respondent. For this matter on 30th of October. This next.
Yes, my lord.
Till number 9,
For the petitioner, for the respondent. I'm filing the assets and liabilities. I've served the copies on the other side as well. My lord,
5.5 lakhs is the reasonable claim maintenance per month.
It may be looked into, my lord. That would
I will
be
go through that.
addressed-
Refer
that
to
would be
copy only
addressed.
now. I'll go through, my lord, the visitation, my lord. I've been
What is
having
going on?
4 hours from 31st of July, your lordship passed the order. 4 hours, my lord, myself and my parents are going and visiting the children at the clubhouse of the apartment where the respondent resides. But that's been going on now for almost 2 months. But kindly permit me to, my lord, pick up the children, take them because they're not small children, but boy is almost 11 years old and daughter is 6 years old.
We'll do one thing. This Saturday, we'll permit him to take the children out and we'll post this matter on Monday.
My lord, with respect to the same,
We'll post this matter on Monday.
My lord,
That day you can
it's-
submit what has happened.
my lord, it's a sincere request as such. I had also submitted prior that the minor son, who's of 11 years of age, has expressed certain concerns And that should be addressed. Why?
Okay.
Because what's going to happen is that now the petitioner, the father himself has idea of the same, and he's been discussing the cases with the child, and the child has been coming back home and has been questioning the mother. That is what's happening on a day-to-day routine, my lord.
We'll tell
My
him
lord, so with
Lordship-
respect to the same, even keeping all of this
to
aside,
do it.
my lord, keeping all of this aside, I've received instructions from a client that she's going to propose, she has a proposal, keeping in mind the interest of the petitioner, which should, if addressed properly, to amicably settle the whole matter. So all I request is that the
Sir,
matter.
she will not allow them to.
No, nothing like that, my
Then-
lord. All the request is the matter may be taken up on Friday. So tomorrow I can have a discussion with the learned counsel.
We'll
And-
have it on Monday. Court is not sitting on Friday.
My lord, then at least this weekend, let it continue 3 to 7, him coming to the clubhouse, because she's looking into a particular arrangement wherein the father would have more
Now, please understand, if for this Saturday and Sunday, we'll make an arrangement. How it works out, we'll see. Basing on that, if it is not working, it's not, as you said, that the children are not happy or whatever the reason, whichever you want to say, you can submit it on Monday. On Monday, because vacation is intervening, so we have to make some arrangement in between also.
Definitely, my lord.
For for this weekend, at least on one day, I think he's having both Saturday and Sunday.
Both Saturday and Sunday.
Saturday and Sunday, let him have on either Saturday or Sunday in the same, like how the earlier arrangement is made. One day, let him take the children
My
outside.
lord,
We'll
the
see.
apprehension is that he would affect the child's mental health negatively, my lord, because
Monday.
yes, my lord, the minor,
Then we will pass orders. On
Well,
Monday, no, if that's the case, if really something like that happens.
I will
Will
file an
not, will not grant anything, will not grant the visitation on, from.
No, my lord. So
10th of-
keeping all the factors in mind, all that I'm asking is that the matter be taken up on Friday. I believe that the client, the respondent herein is willing to be more than fair. She wants the petitioner to also take up responsibilities as a father. So she's trying to come up with a certain arrangement, the intricate details of which have to be worked out. That is all. It will
Already,
definitely
I
put
think
up.
he's paying 2.5 lakhs or 3 lakhs towards the fees.
My lord, in that, not towards the fees, my lord. It is 1,35,000 that has been paid after the residence orders passed. The residence order was passed in the month of April, my lord. Till then, for almost 18 months or more, she was left out on the streets, my lord. She had to survive based on her father's mercy. We have the orders. The petitioner herein, it was also addressed.
It's come. Agree.
Lord, may I make the
as per
submission?
the
No, Lord,
order
one-
passed
The
by this-
petitioner,
Lord, I have one
my lord,
submission.
just one submission.
Sorry, sir, 1 second. My lord, my learned friend is making a submission before your lordship. A responsible counsel is making a submission that the father is discussing the cases with the child. Lord, I will place on record what happened before, last week. My son is in the hospital for 4 days. I am not informed. I see an email from the insurance company saying the insurance claim is rejected. When I call the insurance company, they inform me that my son is in Manipal hospital. I write to the respondent does not respond to my email. I end up in the hospital. My lord, who opens the door at 9 o'clock in the night? The counsel opens the door in the hospital. And the counsel is making a submission about it. Kindly wait one second.
Sir,
Counsel is making
kindly.
a submission. Kindly wait. When the counsel is making a submission, I'm talking about cases. A counsel is representing my wife in the cases before in the hospital, interacting with my son. I did not want to place this on record.
Your Honor, it may be placed on record. Whatever
I will
they
file an
insinuating it,
I will file an affidavit before the court.
it may be taken on record. Let then affidavit be filed. There is no restriction per se. The reason being, I had to file the assets and liabilities, my lord. It was a strict instruction of the court that I have to file the assets and liabilities. You may check the documents, my lord. There's almost 200 pages, my lord. How is she supposed to take care, obtain the documents? I had to work it out with her. So we are not going into
The
the personal
hospital room.
aspects. So there is nothing barring me from. Yes, she herself was sick, my lord. I had made a submission that she herself had been sick. She had influenza. The kids had influenza. The son had to be admitted. So she's never. There's no. The allegation raised here doesn't have anything to do with the custody or the maintenance aspect.
The counsel being in the hospital.
So
room
what wrong does
not-
it do?
Does not expose my son to court cases or court proceedings. But me meeting my son exposes
My
him
lord,
to court
my lord,
proceedings.
considering the claims, let the honorable court interact with the child. It will put all these allegations to rest. This is what we've been asking from the very beginning, my lord, that the child should be interacted with.
Order passed by this court, the respondent mother had placed before this court the statement of assets and liabilities, which will considered by this court on the next date of hearing. Learned counsel for the petitioner father submits that the father has been visiting exercising the visitation from the last 2 months in the clubhouse of the apartment.
And the grandparents.
Huh?
And the grandparents.
More than the grandparents at the clubhouse or the apartment where the mother is residing, he submits that the father may be permitted to take the child, take the children outside the premises and exercise the visitation. The father, as per the earlier order, is exercising the visitation on a Saturday and Sunday. On this Saturday, at what was the time?
It was 3 to 7. I stay in Hebbal, they stay in Whitefield, not 10 to 5. On one day, I will not press for 2. On one day, not 10 to 5, I will take them. Because, but the time I come,
Sunday, there is no visitation there.
no, your lordships, I have granted visitation both Saturday and Sunday. Ma'am.
That's why you are having it from 10 to 5. You will not have it on Sunday.
Or it may be given on Sunday, but not Saturday, let the children be with the mother.
On Sunday or Sunday, the father can take the children at 10 o'clock and drop them back at 5 o'clock. Post this matter on Monday, basing on how the visitation goes on and the further orders will be passed. The father is directed not to keep the children comfortable and he shall not discuss with them about any of the cases, or he shall not talk to the children against anything against the mother.
My lord, also recordings of the kids, my lord. Recording the kids. So the kids have told that the elder son has said that he might be recording because the father's got a phone around. It may be put on record that he might not record because there's precedent as well, wherein during one of the state visitations as such, wherein the father had to meet the child in the park. Instead of spending time with the child,
Because, please understand, please understand from the side of the father also. Now, you will come to the court and say that the boy is very
my
uncomfortable.
lord, the recording,
So to prove
my
the
lord,
court,
not,
to prove the-
not,
that's
my lord,
what,
if it was recording,
they shouldn't be involving in all this.
My lords, the court's mic has been muted, my lord.
Then Rupesh B.
My lord, in this case, for the respondent, I have received the wakalat only yesterday, my lord. I may be given a day's time to file wakalat for the respondents.
You have an interim order in this?
Nonetheless.
BK.
Any interim order in this? No?
Petition by
Land
wife of
council,
wife.
what is your name?
BK Mohan, my lords.
Land council, Mr. BK Mohan submits that his instructions to file wakalat on behalf of respondents. You can go after vacation.
Please.
Pose this matter
Any date?
on 21st of October.
Grateful, my lords.
Yes.
Copy served. minutes.
Yes, yes, I have received the copies. I have received.
It is submitted that the council has already served the copy on the council for the respondent. Yes,
I have received, my lords.
call the pass.
First over matter, serial number 7, list 1, serial number 7. Speak on.
About my lord's issuance of succession certificate, my lords, in respect of Vimal properties. And I brought your lordship's notice, my lords, another order. My lords, it may be permitted, my lords, make few submissions, my lords, on section 370, my lord, that is
Yes,
what is
Take
concerned.
that, provision. Succession Act. Yes.
Because, my lord, the Leonard Single judge, my lord, so the honorable court says,
Hmm.
as per section 370, it is not, it cannot be
Hmm.
issued. But the heading itself, my lords, of the provision says, my lord, restriction on grant of certificates. It's only,
That's
my
what it
lords,
is like,
exception drawn, my lords, to a general rule.
Hmm.
And my lord, the subsection 1 also, my lord, succession certificate hereinafter referred to as so-and-so shall not be granted under this part with respect to any debt or security. That is also not, what I'm submitting is only an exception. And my lords, reference is also made, my lords, to section 212 and 213 of the Act, where it says, my lords, in respect of debt or security to which a right is required by section 212 or section 213, or my lord, is to be established. My lords, in fact, my lord, section 213 also, in fact, refers to immovable property, my lords. That means to say,
Yes.
there cannot be any generalized view which can be taken, say that it is not applicable. And my lords, the section 210 also, my lords, for a moment. Two hundred and 11 minutes.
1 minute.
211. Says, my lord, the executor or administrator, as the case may be, of a deceased person and his legal representative for all purpose, and all property, my lords, is the word used. There's no distinction about movable or immovable. All properties, my lords, is the word used.
What is the other provision you're referring to? 370?
My lord, section 370, my lords, is the provision.
That I've seen.
372, my lords, are for application. My lords, particularly section 372 1D, my lords. It only speaks of, my lords, the right in which the petitioner claims. There is, my lords, a clear distinction, my lords, to 31F, where, my lords, separately the debts and securities, my lords, are mentioned. That means to say, my lords, as per my understanding, there was no necessity to say, my lord, state, my lord, separately about the right and, my lord, the debts and securities, my lords, in the provision.
No, the court had dismissed on what ground?
My lord, saying that it is not, it cannot be
Relying on
issued in
this
respect of
judgment?
immovable properties.
Relying on this?
Not this, my lord. This judgment came, my lord, subsequent to, my lords, the.
Then
My lord,
let's look at the reasoning.
please.
What is your application?
My lords, for grant of, my lords, our understanding was, my lords, we are only the surviving heirs, and it should be issued in our favor. My lords, there was no objection also from, my lords, any person. Your lords may kindly have, my lords, page number 25, para 10, my lords, is.
You're asking in respect of your uncle's property.
Yes, ma'am. We are the only heirs, and, my lords, we are granted certificate by in other proceedings, except this property. That also, my lords, we produced,
Heard, reserved.
published.
Next.
Cell number 9. Cell number 9.
Madam, for the petitioner. My lord, it is that matter, my lord, where my lord had referred the child, my lord, to be taken to Niemann's for mental evaluation. Now, my lord, kindly sees your lordship's order dated 30th of August.
Just what is happening?
We have not gone for the admission at NIMHANS.
Why?
You know, the child is showing.
Huh?
Resistant towards admission, my lord.
What is that?
Child is showing resistant towards admission, my lord. She's not willing.
I didn't get you.
The child is showing resistance, my lord, for admission.
So what are you supposed to do then? Have you brought it to the notice of the court?
My lord.
Why?
There was a order not to move the matter from.
Does it mean that not to move means that you will not, you will not honor the order of the court and you will, whatever you want to do, you will do?
No, my lord, that's not our intention, my lord.
My lord, also, there are certain concerns with the admission as well, my lord.
Yes.
The Mental Health Act, my lord. A copy of that.
No, this is not the stage for all that. This is not your application at all. You cannot come up with all this now. What is to be done now? Shall the court pass an order? Or we take contempt proceedings to be initiated against the mother?
No,
That's the only option left.
my lord, private counseling institution is.
It's
we're
not
willing-
whatever she wants to do.
My lord, it's not even about the mother, my lord. The child is showing extreme resistance, my lord. She is really unwilling to go to that place, my lord. It
She's
is
unwilling
really-
to do so many things. That's the reason why the court has to send her. You are not, what the court can understand is, you don't want her to be normal. If she is in the same set of mind, I think that suits the mother. That's what appears to be.
My lord, here, my lord, indeed, my lord, we completely agree with counseling that is required for the minor child, my lord. We're not even against it, my
You
lord.
have seen the doctor, what did they say? Even to assess what's a state of mind, it cannot be assessed on a 10 to 4 o'clock or on a kind of sessions.
My
You
lord,
understand, in the earlier order also, the court has passed the same order. In fact, the court has spoke with the director of NIMHANS. He said, the manner in which the girl is behaving with her set of mind, it is not possible. Why is the mother not understanding it?
My lord, here, my lord, when it comes to admission, the Mental Health Act speaks about the admission where they have to do 7 days of continuous counseling. And admission is only done when there is an extreme mental health condition that is there.
What do you think that she is normal with what she is speaking?
Indeed, my lord, she needs counseling, my lord. Direct.
You are not a
going-
doctor, I think,
It is
for
not
that matter. It's for the doctors to say. You cannot submit. This is not a legal issue where you will submit that this is not the provision, something else. You are not competent to speak on that. That is a doctor who has spoke. There is a report before the court saying that it has to be done in that manner. Now, by the Google knowledge, one cannot tell the court that how it should be done. It's a doctor's analysis and his treatment. That's how it has to go. The
Indeed.
mother has no business to say anything in this.
My lord, it is not, this is from the Act, Mental Health Act perspective that I was speaking, my lord. My lord, that part when she was admitted there, she was attacked by.
And you take her every day 20 kilometers up and down, and you take her to school.
My lord,
And you
it
tell
is-
the court that, no, the court has to give a finding on this, saying that the mother is not interested. Whatever the mother's behavior is not in the interest of the minor. And the minor who makes those kind of allegations against the father, when all of you are present, and you still feel that the girl is normal, and generally these kind of treatment is in extraordinary or circumstances. Don't you feel that the manner in which the girl was, talking about all the things which has never happened, is it a normal health condition?
My lord, but my lord, the counseling, everything is very much. with
It's
the
not about
best
the
interest.
counseling. It is about the assessment first.
Assessment.
First, you have to understand what is the problem. Once you understand the problem, then the question of counseling will come later.
Indeed, my lord, she has put.
For that, they need to look at her right from the morning to evening. And to assess her, it's very difficult.
Definitely, my lord. My lord, here what is happening?
Let the mother come before the court. I think she requires, then before her, I'll pass an order. Tell her that I'll definitely take it as a contempt. Will suo motu initiate contempt proceedings against the mother. Tell her to come on Monday. Yes, pose this matter on Monday.
Great.
In spite of an order by this court, on several occasions, on one reason or the other, the mother has not joined the child in NIMHANS. when the Nimhans doctors have given a report before the court stating that she has to be admitted, considering the disputes between the parents and and the manner and and assessing the girl as a outpatient is not possible. In those circumstances, an order is passed. The mother on one pretext or the other is not is not complying with the order of the court. And when the father has moved an application, then her counsel submits before the court that the girl is reluctant. It was never brought to the notice of the court, and it appears that there is no intention on the part of the mother towards the welfare of the child. And all the, and she is now coming up before the court saying that it can be as per the Mental Health Act, it has to be other way. It is not, the admission is not required. And now the mother is trying to tell the court, is submitting before the court as a doctor what has to be done, which cannot be appreciated. This is a clear case where the suo motu contempt proceedings have to be initiated against the mother. Pose this matter on Monday. On Monday, appropriate orders will be passed.
Great.
Seal number 25. Amit Kaya,
Respondent.
C.H. Jairaj,
Appellant in this matter.
So who are the respondents in this?
It's respondent numbers 1, 2, and respondent numbers 4 to 7, I represent them.
No, respondent number
Respondent numbers 1 and 2,
1 and 2,
respondent numbers 4 to 7.
4 to 7 you represent. Then about 3, 8 and 9.
Now, my lord,
Huh?
now the interim order before the trial court, my lord, has been rejected. We will seek interim order only against the proposed respondent, my lord, who has purchased this property after impleading.
So no adverse orders to any of the parties.
Please, my lord.
The present MFA is filed. Agreed with orders passed in I number 11. Dated
Dated 7th June 2020.
I number 11 and OS number 356 of 2014, dated 7th June 2024, whereby the court had dismissed the IA filed by the plaintiff. The suit is filed for?
Partition, my lord.
Suit is
Partition.
filed for partition. As which defendant has alienated?
My lord, first defendants 1 and 2, my lord.
Defendants number 1 and 2 had alienated the suit schedule property. Hence, they have filed the IA, seeking a direction not to put up construction
No,
of
no,
the,
not to alter in any manner, nature of the property. Not to alter.
changing the nature of the property and putting up construction over the suit schedule property. In that, the defendant had not, the plaintiff had not impleted the purchaser to whom the property, has not impleted the purchaser. On that ground,
Para 13, my lord, para 13 of the order.
on that ground,
Page 25, para 13, my lord. Para 13 and. Without impleading the purchaser,
you're reading para number 13.
please. ma'am.
Para number 13, it's not there.
It
Internal
is
page
at
number
the end
9.
of that para, my lord, para 13.
Oh. What is the internal page of the judgment? That order?
10, my lord, 10,
10,
please.
temporary injunction to entertain so and so with respect to property, that the injunction is sought without impleading the purchasers who are the proper and necessary parties to this suit and the IA. And accordingly, the court had dismissed the IA filed by the plaintiff. Agree thereby, the present appeal is filed. When the, now, and this, the respondents respondent 1, 2, and 4 to 7 are represented by an advocate. Respondent number 3, 8, and 9. Notice is not ordered no notice is not ordered. Land counsel appearing for the appellant submits that they will file an appropriate application by impleading the purchaser.
Madam, I'm
And
told-
hence a liberty may be granted.
Madam, I'm told application is filed, but not yet served.
That they'll proceed further. It is submitted that they've already filed an application by impleading the purchaser. And they may be given liberty to pursue the said application. Though notice is not served on the respondent so and so, but still this court is passing an order for giving liberty to the petitioner, to the appellant plaintiff to pursue the said IA, as no adverse orders are passed against them. Accordingly, the MFA is disposed of, giving liberty to the appellant plaintiff to implead the purchaser and file an appropriate application.
But the trial court may be directed to dispose of such application, my lord, without being influenced by the earlier order. My lord.
The trial court shall independently deal with the said application without being influenced by any of the observations and the findings of the earlier order.
Much.
That I said so.
Much obliged.
Yes.
Cell number 26. Vikram Unni, Rajgopal.
Lord, defendant's appeal challenging the order of the trial court granting an order of temporary injunction restraining me from alienating or creating any third-party rights over the suit scheduled property. I am the absolute owner of the suit scheduled property, my lord.
What
My-
is the suit?
My lord,
What
suit
is
for
the suit?
declaration, my lord. Declaration that the sale deed in my favor is null and void.
Date of your sale deed?
Date of the sale is 2012, my lord, which is at annexure Annexure D, 10/12/2012.
This injunction is restraining you from interfering.
Restraining me from alienating or creating the third part rights.
And what about, he sought recovery of position also?
He sought recovery of possession also. I've been in possession since 2012. My lord, the scheduled property originally belonged to my father, one Ramachandra Upadhyaya. He passed away in the year 2007. Subsequent to his death, family members entered into a partition deed.
No, instead of passing so many orders, let them come, we'll dispose of the mail.
But I'm seeking for a stay of the proceedings. The party is coming up on 27th for plaintiff evidence, my lord. The suit is ex facie barred by limitation. Court fees is not paid. I kindly see the receipt.
Will be decided. Now you're on an IA not to alienate.
Yes, my lord.
No, nothing will happen in 15 days when once the other side comes. And question of staying further proceedings will not arise in this. The petition, the appellant is permitted to take out notice on the counsel appearing for the respondent before trial court. It shall file a memo to that effect. If the memo is filed on by 14, list this matter on 16.
Grateful.
Cell number 27.
For appellants in this matter, my lords, a comprehensive suit for declaration possession. That's my only prayer before this honorable court is, the respondent is trying to create third-party rights. The facts of the case are, my lords, in the year 1948, my father succeeded the property of survey
So
number.
you're seeking declaration and recovery of possession.
Yes, my lords.
And what is the sale deed in favor of the defendant? Which year is that?
My lords, the facts are different, my lords, likely different. The thing is, my lords, after the purchase of the property, defendant number 1 has purchased the property from my father. After purchasing it, there was 79 A and B proceedings initiated in the year 1996 itself. Subsequently, after this, the defendant number 3 has purchased the property from defendant number 1, which already seized by the government. After purchasing 6,000 square feet, now the remaining portion which I was left over, that is 4 acres, in that he has been encroached. Initially, I filed a suit for injunction. Injunction was granted in my favor. Subsequently, when it was vacated, again he has encroached and has made a construction. Subsequently, I withdraw the original, that injunction suit, and I filed a comprehensive suit now. So initially, the second suit also, the interim order was given by the honorable court, and subsequently it has been vacated. My only apprehension is third party rights should not be created. That's my only request, my lord.
How your application is dealt with by the trial court? Let's see that.
Yes, my lords. And there is no proper findings given by the trial court, my lords. Madam, the reasonings will start from page number 65. Or may I just read the entire order, my lord?
Reasoning.
Yes, my lords. Page number 65, para 8. In order to avoid the petition
The wrong file.
66, my lords. I have perused the materials placed by the parties to the suit. 66 page number. Internal page 11 of the order.
66
Yes, ma'am.
is affidavit.
My lords, the impugned order starts from page number 82.
Impugned order starts at page number 15. 14 it starts. 24th April 2024 order.
Yes, my lords.
It starts at page 14.
My apology, my lords. The
Yes.
page name is different.
Yes.
In that, my lords, internal page or order, page number 11. I have perused the materials placed by the parties to the suit. The plaintiff has filed the suit for declaration and injunction and for recovery of the position with respect to the suitable property. It is his contention that the plaintiff that the land measuring 3 acres of the land out of survey number 62/3 was sold by my father of plaintiff and plaintiff on 21/4/1986, and another extent of 3 acres of land was sold in favor of one Gulzar on 1/12/1986. Subsequently, 18 guntas of land in survey number 62/3 was acquired by the government for expansion of the road leading to Parapna Agrahara. The plaintiff and his father retained 4 acres, 5 guntas land out of 10 acres, 23 guntas of land, and the suitable property is the land measuring 6.5 guntas out of 4 acres, 5 guntas of land retained by the plaintiff. It is stated that the 3 acres of the land sold in favor of the defendant number 1 was acquired by the government by virtue of the proceedings under section 79A and B of Karnataka Land Reforms Act, order dated 22/9/1986, and the government has taken the position of the same. Thereafter, the defendant number 1 has sought to sell an extent of 6,540 square feet of land in 3 acres of land in favor of the defendant number 2 white sale deed dated 30/5/2013. And on the basis of the sale deed, the defendants are trying to interfere with the plaintiff's peaceful position and enjoyment over the suitable property. And in this behalf, IA is filed requesting the court to pass an order of temporary injunction restraining the defendant number 2 from alienating the suitable property. Admittedly, the suitable property and the written statement scheduled property are entirely different. The written statement scheduled property is the schedule of the sale deed dated 30/5/2013. It is not demonstrated as to how the plaintiff has apprehended that the defendants may alienate the suitable property without any title deeds in their favor, and the relief sought by the plaintiff is not with regard to the restoration of position, but with regard to the rights of the plaintiff number 2 to alienate the
So the
property.
court on the point that the written statement scheduled property and the plain property are not one and the
It is
same.
one and the same. My lords, I'll demonstrate. My lords, the plaintiff which he is claiming which he has retained the property is 4 acres, 5 guntas, my lords. Wherein the defendant herein, the third defendant which he has purchased out of that 3 acres which was acquired by the government. Government 79A and B, the proceedings were initiated. So that order has become finality. 1996. Till today, they have not challenged it, even though the order has been repealed. Now, he is claiming the title from defendant number 1. Nor his case is that he has purchased it from my father or I have sold it. It is not his case.
Your father has sold to D1.
My father has sold it to D1.
From D1 in turn, he has purchased it.
True, my lords, when he cannot purchase it because the property is already vested with government. How can he purchase it? That is the question, my lords, that the trial court did not understand it properly. He is not claiming through my father, or his case is not that I have sold the property to him. His case is he has purchased it from D1. He has purchased it from D1 recently, my lords. This has happened 1996. The 79 AB proceedings are being initiated. When the matters are seized
What you are
before
saying is the property which already vests with the government.
Yes, my lords, that
has
is being purchased by defendant number 3.
Hmm.
How can he purchase, my lords? prima facie.
He purchased.
He purchased, he has
That is,
purchased.
he has.
I am not disputing that, my lords. I am no way concerned.
That property.
Yes, my lords.
Which is already acquired by the government.
Yes,
If he is trying to sell it, how is that it is going, what is the,
My lords, that is not the question here, my lords. Now he has encroached 6,500 square feet of my 4 acres, which was left over by my father. That is the question, my
so
lords.
first that has to be decided, which is the property encroached by him.
Only
As far as a.
through a
written
trial, my
statement
lords,
property
only
is
through the
concerned-
trial it has to happen, my lords.
Yes.
For
For that,
only,
how can they, no, as far as the written statement scheduled property is concerned, you have nothing to do. You are only talking about some encroachment.
only
For
an
that-
encroachment.
No, for that encroachment, how
Yes,
can
ma'am.
there be an order that the entire property should not be?
I
alienated?
never questioned about the entire property, my lords.
But
I am
you're
only
saying it's
questioning.
not to alienate. The
Not
entire
to alienate with
property.
respect to that 6,450 square feet is my question, my lords. That's the only prayer before this honorable court, my lords. My lords, suppose, my lords, I have some documents to show that he has forged documents and obtained the orders, my lords. I am producing two, and he is claiming that he has purchased, he has taken the sanction plan.
It has to be heard. It has to be heard along that the.
My lords, I
respondent
am not
will-
requesting for the stay of the further proceedings, my lords, because I'll be affected.
Even this also, not to alienate also, the court has to be satisfied on that.
Until
are
next
saying-
date of, until they come and make their submissions, my lords.
Let
It
them-
has to be protected. The only reason is, my lords, now all along, if at all he alienates, again I have to implead them.
Is this order passed?
Recently,
24th
my
of
lords,
April,
very recently.
2024.
Very recently.
That at the end of 15 days, it can wait. The
Next.
appellant is permitted to take out notice on the counsel appearing for the respondent, shall file a memo to that effect by 14th of October. If it is filed, post this matter on 21st of October.
May, one indulgence, my lords. Until they come and appear, my lords, let there be some status quo, my lord.
No, for that,
No,
the
status
court-
quo, my lord. I'm not asking that.
Status quo is an order, it's a double-edged sword.
Fine, my lords.
Can't
At
be
least third-party rights may not be created, my lords. Only that
But that also I'm not convinced. Yes, next.
Cell number 28,
obliged.
J. Kumar K. for appellant.
In this matter appearing for the appellant, my lord. Lord, this is the plaintiff's appeal, my lord. Plaintiff filed a suit for injunction, my lord. Again, it's the defendant. Trial court has come to the conclusion that, my lord, a plaintiff has made out a prima facie case and grant an order of only in part allowing, but direct the parties to maintain status quo. My lord, my application, my lord, page number. Suit for permanent injunction, restrain the defendant from interfering with the plaintiff possession.
No,
My
the
lord,
court
plaintiff,
says status quo.
my lord,
Oh, the court says
yes,
status quo.
allowed the
What is
IA.
What is the case of the plaintiff?
Plaintiff purchased property under the sale deed of 24/3/2016.
Hmm.
The sale deed was executed by the court, my lord, under the specific performance suit, my lord. An agreement was executed and I am nominated as a nominee on behalf of the decree holder and I entered into, and the court has executed the sale deed and I am in possession of the property. Now the defendant's claim, my lord, is in respect of some other altogether property and they are nowhere concerned with regard to the scheduled property, since in the defendant written statement clearly admitted that they have a site number 1 and 2. This site is totally different. My lord, may I kindly look at page number 18 of the impugned order. The trial court findings, my lord, is that whether the plaintiff has made out a prima facie case, court answered. my
What is
lord,
the case of the defendant?
my lord, defendant case, my lord, is that they are purchased site number 1 and 2.
Yours is?
My site number, my lord, is site number 20. 20 and site number 1 and 2.
So even though these numbers can't be adjacent to the other,
Not, because your lordship may kindly see the page number 29, the plain schedule.
please come to the order.
Order, my lord. Page 18, my lord, findings, my lord. All for 3 points, my lord, court answered is affirmative, affirmative, affirmative. Balance of convenience, yes. Balance and irreparable loss will be caused to yes. The reasoning, my lord, is come to the page number 8, para number 8, my lord, page number 18. Point number 1. As per the case of the originally the scheduled property belonging to one Muniappa, during the lifetime of he was in possession and enjoyment of the same. After his demise, revenue records mutated in the name of his wife Mangamma, and subsequently she has gifted in favor of her son Lokesh through a registered sale deed and registered gift deed dated 1/2/2012. It is also said that said Lokesh executed an agreement in respect of scheduled property in favor of one Ganesh and Karthik. It is also stated Lokesh has failed to execute the sale deed. Therefore, Ganesh and Karthik have instituted a suit in OS number so and so before the City Civil Court, Bangalore, for the specific performance of sale agreement which came to be compromised and decree, and in the meantime Ganesh and Karthik have assigned the decree in favor of the plaintiff, and therefore plaintiff has assignee of the decree filed in execution number so and so and obtained a sale deed on 24/3/2016. Though the process of the court and thereby he has acquired the title and possession over the property, the objection raised by the defendant is that gift deed and execution of proceedings are collusive in the guise of the decree, and sale deed of the plaintiff is claiming right over the property of defendants. Your Lordship, kindly look at the written statement, the property of the defendants. Page number 38 of the written statement I have produced, their contention and their statement.
Please read para number 10 of the order.
The defendants have produced several documents to establish their claim in respect of their two sites. Though the different documents produced by defendant prima facie substantiate they are in possession of two sites, whether those two sites are very same sites in which plaintiff laying claim or to the different site is required to be determined by the trial. It is vehemently contended by the learned counsel appearing for the defendants that when the defendants are liable to show the existence of their two sites, the existence of site numbers claimed by the plaintiff is highly improbable. The same can be determined only after the trial. Lord, may kindly look at the schedule and my schedule. My schedule site number 20 is 40/19. Their contention 120/20. 120/20 and 40/19 are both are one and the same, Lord. Highly impossible because the site number 1 and 2 they have stated para 38. May
That's
kindly.
what the court also said, highly improbable.
Yes, Lord, my submission before the court is that when the tours.
No, it is. No, you assert your title by way of some.
Yes, my lord.
They are also asserting the title.
Yeah, absolutely.
So that the numbers are also, his numbers are 1 and 2, yours is 20.
20.
Now, according to you, they are interfering with your position.
Yes.
As it is, nothing would be there to for the court to ascertain it.
My lord, that is the matter of trial is that is the matter of trial is concerned, my lord. When there is a sale deed and there is a possession transferred and earlier, my lord, their possession of 1956 is altogether different. My possession is altogether from different. My boundaries are specific.
So how both of you, where is that overlapping and where is this encroachment?
Therefore, page 38 of the written statement, kindly look at, my lord, please. 38, last 6 lines, my lord, in the written statement defense.
According to the court, prima facie case is your sale deed.
Yes, my lord, the court comes to conclusion.
He also has a prima facie case of sale deed.
That's finding is error, and if the once court comes to conclusion, plaintiff is made out a prima facie case, court ought to have granted an injunction. My lord, page 38, my lord, may I read the last 6 lines, my lord?
Page number?
38. 38. It is the written statement defense. From bottom 7th line, my lord, I am reading. The word started, the defendant being the owners of property bearing number 1 and 2, 27th Cross, Jayanagar, Bangalore, thereby bearing number 1 and 2, measuring 120 into 20 feet. Originally, property bearing was granted Patel Sitaramaya by village panchayat, so and so, and property number 2 was purchased on 5 April 1956 from Anantaramaya, who was allotee of the Achamma and the mother of the defendants. The copy of the sale deeds are here with produced indicates the western boundary of the property number 1. Actually, the property of number 1 and 2 are acquired by CITB and the compensation was granted as per the property when they take into consideration. This is their defense. Please kindly look at 120 into 20 measurement and schedule property playing. Kindly look at page number 29. Page 29 plain schedule.
Anyhow, there is an order of status quo, maintain status quo, let others come.
That's we are challenging before the court. Once I made out a prima facie case, court ought not to grant it. Status quo will
Then that the court shouldn't have said prima facie case then.
They have sailed it only. That is the error. That error we are before the court.
That's why we'll record that without there being a prima facie case, court said it's a prima facie case.
One side court held, my lord, is having a
respondent. That's not a case where the court can grant an injunction. The notice to the respondent same. If the memo is filed by 21st, post is marked on 23rd. Yes.
Till number 29, yes, Venkat Subbarao for appellant.
There are two connected matters. between same
I appear
party.
for respondent number 1 and 3, my lord.
Post along with so and so on 29th of October,
It's a fresh matter little earlier.
on 16th.
Great.
Serial number 30. Reader G.
At the request of land council for the appellant. Yes.
I appear for the appellant, my lords. The defendant's appeal against order of injunction granted in favor of the plaintiff. The plaintiff claims that he is the owner of a particular property number 27 PID so and so, third cross, Yedur. He has purchased the property under a sale deed of 2011. The defendants entered appearance and they are claiming title to a property which is different, 27/2, which is on second cross. That is the defense taken by the defendant. They have purchased the property in the year 1997 in two portions, brothers, and they have amalgamated it in 2006. The court notes that the two properties are different, that there is no iota of doubt that the plaintiff's property is different from the defendant's property. But on the mere assertion by the plaintiff that there is an attempt to interfere, an injunction is granted against me. Now, even in the impugned order, there is a specific observation that this should not be construed as interfering with the other property. But under the guise of that interim order, now the plaintiff is trying to interfere with my possession and therefore I am constrained to file the appeal.
Let's see the order.
The order starts at page 12, my lords.
Come to the reasoning part.
Reasoning starts from page number 19. May I read, my lord? The plaintiff has filed a suit for perpetual injunction claiming that he is in possession of the property and defendants are interfering with possession and enjoyment of suit scheduled property. Suit scheduled property is non-agricultural land
When
described.
was it purchased by the plaintiff?
Plaintiff purchased it in the year on 13/6/2011. The schedule of the property I'll skip for the
Yes,
present.
yes.
The plaintiff claims that he has purchased the property, whereas the defendants contended that they have purchased their property on registered sale deed from Chinnamma and they are in possession of the property. The defendants have contended that since there is a dispute regarding title, the suit for injunction simpliciter is not maintainable. In order to establish prima facie case, plaintiff has produced documents. I have perused the documents produced by both the plaintiffs and defendants in detail. The plaintiff has produced sale deed dated 13/6/2011. As per sale deed dated 13/6/2011, Muniamma, represented by M. Kannan, has executed sale deed in favor of the plaintiff in respect of property bearing number 27, municipal ID 1/12, PID so and so, situated at third cross, Anjaneya Temple Street, Yedur, measuring east to west 98 and north to south 35 feet. The property described in the plaint as well as the schedule of the sale deed are one and the same. The plaintiff has also produced power of attorney executed by Muniamma in favor of Kannan. Power of attorney executed by owner Muniamma is registered in the office of Sub-Registrar Jayanagar. It is clear from the power of attorney that M. Kannan was authorized to sell the property for and on behalf of Muniamma. A registered rectification deed executed on 23/6/2011 shows that there was some mistake in the road name mentioned in the power of attorney, which has been corrected. It is clear from the document maintained by BBMP that after execution of registered sale deed, name of plaintiff has been entered in the property extract pertaining to number 27. BBMP has issued Khata certificate and certificate showing plaintiff is the owner in respect of suit property. I have produced the documents produced by the defendants also.
So your vendor is common vendor. For both of you, vendor is.
No, my lords.
No, it's Chinnamma.
That is Muniamma, my lords. Plaintiff's vendor is Muniamma, defendant's vendor is Chinnamma, and plaintiff's vendor claims title through a group panchayat,
Yes, yes.
sale certificate.
Yes.
Para 8, my lords. I have perused the documents produced by defendants also. Documents produced by defendants show that the defendant number 1 purchased property number 27/2 situated at 2nd Cross, 6th Block, Yedur, Jayanagar, measuring 55 feet east to west and 30 feet north to south as per sale deed dated 18/2/97 from one Chinnamma. Likewise, defendant number 2 has also produced documents showing the remaining portion of property bearing 27/2 situated at 2nd Cross, measuring east to west 45 feet and north to south 39 feet from Chinnamma. These documents show that the name of the defendants are entered in the property extract pertaining to property number 27/2. The Khata extract clearly shows that the property purchased by defendant is old number 27, new number 2, whereas in the document produced by the defendant, the property is 27/2. If both the sale deeds are considered together, then the property purchased by the plaintiff is property number 27, whereas the property purchased by defendant is 27/2. The property purchased by second defendants are situated at 2nd Cross, whereas the property purchased by the plaintiff is at 3rd Cross. So the sale deed produced are with respect to two distinct properties, one belonging to plaintiff and another belonging to defendants. Apart from this, the written statement contents makes it clear that the property of plaintiff and property of defendant are different. Suit for injunction simpliciter is maintainable when there is no cloud on property. As per decision of the Apex Court in case of Antula Sudhakar, etc., where a cloud is raised over the plaintiff's title and he does not have possession, a suit for declaration and possession with or without a consequential injunction is the remedy. Where the plaintiff's title is not in dispute or under a cloud, but he is out of possession, he has to sue for possession with a consequential injunction where there is merely an interference, plaintiff's lawful possession or threat of dispossession. It is sufficient to sue for injunction simpliciter. In this case, since the claim of the defendant is with respect to property number 27/2 situated at second cross, and the claim of the plaintiff being property number 27 situated at third cross, in my opinion, the claim made by both the parties are not in respect of one property, but two distinct properties. And there is no cloud over plaintiff's title. Since both properties of plaintiff and defendant are distinct and separate, the plaintiff has shown that he has purchased the suit property by virtue of sale deed and revenue records are mutated in the name of the plaintiff. In my considered opinion, plaintiff has shown prima facie case his possession over suit property. This suit being one for perpetual injunction, possession as on date of filing of suit plays importance, and since the plaintiff is shown to be in possession prima facie in my considered opinion, prima facie case lies in favor of plaintiff. Property of the defendants are different and they have failed to show that plaintiff is claiming right over the property. Apart from this, there is a triable case made out by the plaintiff as some of the boundaries are disputed. The finding is to be given after taking evidence in this regard as considerable time has lapsed after execution of sale deed in favor of plaintiff as well as defendants. The name of person mentioned in the boundaries might have changed due to subsequent acquisition. Therefore, in my considered opinion, plaintiff has also made out triable case. Prima facie case includes chance of success and triable case, and both have been shown by the plaintiff. Therefore, in my considered opinion, plaintiff has shown prima facie case lies in his favor. Since these 2 points are interrelated to avoid repetition, they have been dealt with together. While answering point 1, I have concluded plaintiff has made out prima facie case. Suit is for injunction and plaintiff is alleging interference by defendants. Suit property is a vacant site and if possession of property is
That's
interfered
in the order.
Last paragraph, my lords, in the before point number 4, it is necessary to mention that temporary injunction is not an obstacle for defendants to enjoy property number 27/2, which they have purchased under 2 sale deeds as suit property and property of defendant are different.
No, it is like this. According to him, there is an injunction. According to you, he is owner of a property in third cross or second cross. You are on the other. So it's your case that you are not interfering with his position.
Yes.
And then in that case, if the injunction is granted, how are you affected?
My lords, I made the same mistake when ex parte injunction was granted. I proceeded on the assumption if I just place the facts, injunction will not be granted because I am not interfering. That is why now, after the injunction is granted, he is interfering with my property.
No. Now the court, now your properties are like distinct and different properties.
Yes, my lord.
So it is not that it's an adjacent property.
No, my lords.
No, under
Different
the case
process.
of it, he cannot because they're 2 different properties. How can he interfere with your property?
My lords.
Court has only granted injunction in respect of his property, not that the court has permitted him to interfere with your property. It is if the court can understand if both of them are adjacent ones, not even adjacent properties. So that's a whole basis for the court to grant injunction.
My lords, I have not even attempted to interfere with his possession because my property is different. If I were to claim title to his property and I am claiming that that same property is mine,
That
then
we will record and clarify.
yes, my lords. Also, my lords, if at all the plaintiff were to be claiming that the property owned by defendant in his possession is the property which I am owning, then my lords must consider that my sale deed is in the year 1997
No,
and
that is not his
2011.
case.
So
No.
prima facie, if my sale deed, I am in possession of the property and he is claiming that property, unless he asks for declaration, he cannot get an order against me.
You know, he's not asking. That's a finding of the court.
Therefore, my lords, when the 2 properties are distinct and I am not even making a claim to the plaintiff's property, where is the cause of action, my lords?
That is his suit. That's his case. You are saying that, no, I'm not doing anything. My property is different. His property is different. All that were considered and passed an order.
My lords, all that was considered, my lords, but then there is an injunction against me when I am stating that I am not interfering with his possession. At least my statement could have been recorded that, okay, properties are different and therefore there is no cause of action.
No.
There is no cause of action because I am not interfering.
That will be decided eventually in the suit.
Yes, my lords, in trial. But the difficulty because of which I am before my lords is that in the guise of having this order, 27/2 is trying to interfere.
That we will record.
I have not filed wakalat in this matter. Kindly have it on Monday, I will file because.
That will dispose of the matter.
Yes.
The land counsel, so Mr. Vijay Kumar, submits his instructions to file wakalat. Post this matter on Monday.
Yes.
On that day, the matter will be disposed of.
Yes.
Number 31, Jayaprakash Reddy M for petitioner, Prasanna Kumar.
For the respondent,
For respondent.
my colleague has some inconvenience today. This matter may kindly be taken up.
How many times this has to be listed? On one reason or the other, it is getting adjourned. When there will be convenience for your colleague?
Because this is a case for me, is a pro bono case.
Because she's
I
a lawyer
understand.
colleague.
So every time you're inviting the senior counsel to come, you should have informed him at least.
We have informed, my lord.
When, madam?
My colleague informed,
Any, Monday.
please.
Yes, at the request of land counsel, the respondent finally on Monday, no further adjournments will be granted.
I think it may be come in the top of the list, otherwise your lordship can see it may not be
That's, Monday is the last working day, and then Tuesday, not Monday, Tuesday.
Tuesday.
Even the other matter also, on that Monday, that contempt one I posted, no, not Monday, let it be on Tuesday. Tuesday.
Please, ma'am.
This matter also on Tuesday, not on
Tuesday,
Monday.
please.
Before matter also. Any of the matters have been taken on to Monday, all that on Tuesday.
Till number 32.
Anita, tell the others also. Any matter that is posted on, I was under the impression that it is Tuesday. That is. Yes,
Serial number 32, I appear for the respondent.
he seeks time.
Radha, why?
At the request of land counsel, the respondent poses matter on
Uh,
29th of October.
Little early, ma'am.
29, 10.
Kindly little early.
Syllabus.
Middle week in the March.
What is this?
Middle week in the October, 21st.
You want it on 21st?
Yes.
21st.
Great.
21st, my lord.
21st.
21, 10, sir.
Very
Serial
well.
number 33. E. Suguna. Sudha. For
Petitioner.
petitioner, YD Harsha for respondent.
Petitioner wife,
Where is the husband?
married.
Respondent advocate.
My lord, this is the impugned order is annexure A, my lord. I challenge portion of the order.
Because anyhow it's 2020 RPSC, council is not there. Finally, it has to be heard.
Yes, because my, I was denied the maintenance, not granted in my favor, my lord.
Coming up
Only
with
my
the-
daughter has been granted maintenance.
Hmm.
So even though I have produced a salary certificate, that was not considered at the time of passing.
No
this order.
representation on behalf of the respondent, counsel for the petition is present. Poses matter on
Lordship, may kindly fix the date. my lord.
4th November.
Serial number
Much
4. Guru Rajesh.
This also no representation for the appellant. Yes.
411. Serial number 35.
35, I appear for the petitioner, my lord. That I am informed that, my lord, that they have already obtained a divorce. They have settled the matter. That based,
It is submitted that the parties have settled the matter. They'll file a memo in that regard. Poses matter after vacation
please, my lord.
on 22nd of October.
Oh, bless.
Serial number 36. Bhushani Kumar for petitioner.
Appearing for respondent.
Yes, your lordship.
Hmm?
Lordship, today, we have transferred rupees 1 lakh to them. And this matter is likely to be settled, your lordship.
Is it so? They have-
Actually, learned friend has actually conveyed the 1 lakh will be transferred today.
No, she says already transferred.
Yes, your lordship.
50,000 is already transferred.
50,000, it will, due to the limit, it will be transferred after 24 hours. We have already transferred.
Hmm.
So it is likely to be settled a day.
We'll have it on Monday.
No,
So
Your
every day, no, every day limit 50-50 you transfer, we'll hear it on Monday.
No, your lordship. Matter is likely to be settled. Kindly, it may be
It is
listed
submitted that
after
today they've
21st
already
October.
transferred 50,000 and another 50,000. They'll transfer it by tomorrow. Tomorrow, post this matter after vacation on
After
21st of October.
Yes, your lordship. Grateful, your lordship.
37. Contraju NK
I am appearing for the
for
petition.
petitioner. E.
Yes, your Lordships have directed me to produce the list, memo of calculation.
For all the advocates, a vacation mood has come. No representation for the, as per the order passed by the court.
Malas, this
Calic-
order, malas, ex parte order, malas, that has to be set aside and remanded back to the malas,
But
family
he has to
court.
be there. Inform him, we'll take it up on Tuesday.
Please, malas.
Post this matter on Tuesday.
Obliged.
No representation for the respondent, counsel for the petitioner is present before the court. And also a calculation memo is filed before the court today. Yes.
Serial number 38. P. Ravindra.
Lordship, I bear for a respondent, Lordship.
Yes.
We will file objection in 2 weeks, stay may be granted, Lordship.
You have stay in your favor?
Petitioner, I am for petitioner. Page is for admission.
No. Any interim order in your favor?
No, ma'am.
You are the wife
I am for wife.
seeking
yes.
enhancement of the.
Not
Who-
enhancement. My petition has been
Itself is
dismissed.
dismissed. Who moved this memo?
I only moved.
You moved?
Yes,
What do you want in this for 2024 now?
admission.
The counsel for the respondent submits that he'll come up with objections. Pose this matter after vacation on 11th of November.
Cell number 39. Edgar Ramakrishna is for
Respond for 1 and 2, my lord. You have
Devaraji.
not served a copy. Not received any copy.
Sir, copy is served.
Oh. And received
Yes,
only hand summons, my lord.
I will.
Any interim order in your favor?
Yes.
Counsel for the petition is permitted to serve notice on the counsel appearing for the respondent. Are you complying with the interim order?
Please.
It is submitted that they are complying, they have already complied, they are complying with the interim order passed by this court. Pose this matter on 12th of November. Yes,
I will serve the one set of court. Today I will.
serve him.
Yes, yes. Okay.
Yes,
Interim order, my client.
interim order earlier granted is extended till then.
Yes.
Yes.
Cell number 40.
Respondent.
Lords, they filed an application seeking vacating of stay, my lords. The interim order that is granted by this court is that we are only permitted to lease or rent the property because I am in possession of the property, he admits it. Now they are saying that in the vacating application that we are creating third party interests. No documents are produced to show that we are creating any third party.
Anyhow, the MFA has to be heard.
Please, my lords. My lords, it is the case of the plaintiff that the property originally belonged to his grandfather by name Susai. And he has executed a gift deed in favor of his grandson, that is the plaintiff, under a registered gift deed dated 7/4/2018, my lords. He says that I am the son of Susai, the grandfather. I am the uncle of the plaintiff. He says that I am in permissive possession of the property. The grandfather died on, he died on 11/8/2016, my lords. No, sorry, my lords.
How can the gift deed be thereafter?
Sorry, my lords. He died prior to, I don't know the exact date, but what has happened is, in the property that is gifted to the plaintiff, the survey number is wrongly mentioned. But he gets a gift deed executed by the wife of Susai, saying that the property that is gifted to him under the gift deed is the property which is the suit schedule property. I claim that my father has executed a gift deed in my favor under a registered gift deed dated 27/2/2013. That is
In
the
respect of this
this is the
property where
same
you're
property.
staying.
There's no dispute with regard to the survey number. So this is the only dispute, my lord. He wanted an injunction restraining us from doing anything with the property. We approached this honorable court permitting us to let out the property, lease or rent, and that is the only order that is passed, my lords. My lords, admittedly, I'm in possession of the property. Prima facie documents show that.
Yes, yes.
Please, my submission is. Blanket, my lord, there should be some accountability. What is he is going to lease, what is the rent he is getting? Because I have also claimed for damages in the suit. He cannot.
But you can file the same before the court.
Yes, let them file a receipt.
File
What are the
statement
rents
before
they
the
are
court,
receiving,
like,
to whom it has been let.
Please, my lords, I will file a statement about what is the
According that,
property.
with that we'll dispose of.
Yes.
That she can let out, she can lease
Will
the
not
property.
with
And
accountability.
whatever is
They should submit accounts to
the
the
rent
court.
is deriving out of it, that should be accounted before the trial court. Yes. Agreed with orders passed in I number 1, invoice number 1605/2023 dated 26th October 2023. The defendant is before this court. The plaintiff had filed a suit for
For
declaration.
declaration, that I am the owner of the suit schedule property under the guise of the gift deed executed by grandfather. in
And
year
also for
2000.
damages.
And also
recovery
for
of possession.
possession and damage.
Has filed a suit for declaration, recovery of possession, and for damages. In that, he have filed an IA number 1, seeking a temporary injunction from alienating or encumbering the property by way of gift, sale, mortgage, lease, rent, lease in favor of the third parties. The trial court had allowed this application and restrained the defendants from alienating or encumbering the suit property by way as sought for by the plaintiff. Agreed thereby, the defendant is before this court. And this court by order dated 21/12/2023, this court has granted interim order whereby the order dated 26/10/2023 passed by the trial court is stayed subject to the condition that the appellant defendant is permitted to only lease or rent out the scheduled property till the next date of hearing. The plaintiff, the relationship between the plaintiff and the defendant is plaintiff is the nephew.
Please.
Plaintiff is the nephew and the defendant is the junior or senior paternal uncle.
Junior uncle.
Defendant number 1, my lords.
Defendant
Is
number
the
1.
is the junior paternal uncle of the plaintiff. It is a case of the plaintiff that the suit scheduled property is gifted to him by his grandfather by a gift deed dated 7/4/2018.
2013.
13.
Lord, for
13
my
is,
gift is first.
Huh?
Lord, this gift deed is executed in my favor is on 27/2/2013.
27?
2013. I claim
execute-
ownership under that gift deed.
And I think you have said the other way.
He's
Mine
is
is-
subsequent to one.
Subsequent, but my lords, what I've said.
No. How you have submitted it, like first is yours, second is his.
No,
Please, my
his
lords.
gift deed is 14/2/2015.
There is a mistake
That
in my
executed a
opinion.
gift deed in favor of the plaintiff on 27/2/2013. 13, and the uncle is in permissive possession of the property. It is a case of the defendants that his father has executed a gift deed in his favor on 7/4/2018,
No,
where
14/10/2015.
14/10,
2015.
7/4, defendant number 1 has executed another.
14/10/2015.
Please.
2015. And in fact, in the defendant, in the gift deed that is executed by the grandfather in favor of the plaintiff, the survey number of this house is not mentioned.
It is
There-
mentioned. It is wrongly mentioned, my lords. There is a survey number.
Wrongly mentioned.
It is wrongly mentioned. And later, the grandmother clarifies by way of a document that it is one and the same. It is a case of the defendant that even it is, according to the defendants, the plaintiffs have also admitted that they are in possession of the property. The trial court, while allowing this application filed seeking injunction, have observed that on careful comparison of the boundary particulars of the property, one involved in the gift deed relied on by the plaintiff as well as the gift deed relied on by the defendant, prima facie discloses that the boundary particulars of the property involved in both deeds are one and the same and property number only differs. Whether the plaintiff as well as defendant number 1 have acquired right over the suit property on the basis of respective gift deeds relied by them or not is to be decided only after a full-fledged trial. By taking into consideration the nature of the suit and the dispute involved in the suit, the preservation of the suit property in its existence till adjudication of dispute is very much necessary. And the court felt the plaintiff has made out a prima facie case for the grant of injunction, accordingly restrain the pastor injunction, restraining the defendants. Next, land counsel appearing for the appellant defendant submits that the defendant is in possession of the property And it is also admitted case of the plaintiffs. The trial court had failed to consider these aspects and restrain the defendant from mortgaging, encumbering, or in any manner dealing with the property. It is submitted that if by passing such an order, lot of inconvenience is caused to the defendant. And in fact, balance of convenience lies in his favor as he has been in possession of the property. It is submitted that this court had permitted the defendant to lease the
Lease and rent homes.
Operation of the improvement of the site subject to appellant is permitted only to lease or rent out the suited property.
1 million.
The order dated 21/12/2023.
The appellant was is permitted to lease or rent out the suit property till the property. It is submitted with the land council that the same order may be made absolute in the interest of justice. Next para, land council appearing for the respondent plaintiff submits that considering the gift deed, which is much prior to the gift deed of the defendant, the trial court had rightly granted the injunction. He submits that he has even sought for as the defendant without any manner of right and title is enjoying the property. That the plaintiff has also sought for damages. Now, if this order is made absolute and the defendant enjoys the property in the manner in which the defendant wants, and there will not be any accountability. And in the event the suit is decreed, it is very difficult to ascertain the damages. Next part. And he submits that the appeal is liable to be dismissed. Next part. Having heard the counsels on either side, there is some material on record. Both the parties are plaintiff and the defendant are related. Plaintiff is a nephew and the defendant is the uncle.
First
Both
defendant,
of
first defendant, there are two defendants.
first defendant is uncle. The plaintiff and the defendant are both relying on a gift deed that is executed by the grandfather and the father. There is with regard to the number, what is that number?
Survey number,
What
Property
survey number it
Uh,
is?
property
House
number.
number,
Property number.
property with regard to property, number of the property. There is a dispute. The plaintiff suit is for declaration, recovery of possession, and also for damages. The trial court went wrong in granting injunction, restraining the defendants from using the property as admittedly he has been in possession of the property. If it is the court wants the property to be protected till the suit is till the suit is disposed of, some order, a balancing order ought to have been passed by the court. This court by way of an interim order had permitted the appellant to lease or rent out the scheduled property. In the considered opinion of this court, this order is a balanced order whereby it will not be both the parties. The property will be preserved and no third party rights are accrued. And in the event the suit is decreed, the property is very much preserved. But as rightly pointed out with the accounts for the respondent, unless and until the property that is leased out and those account that there is unless there is a proper accounting of the same, then in fact the plaintiff would be deprived of his right and the ascertainment of the damages. In that view of the matter, this court is disposing of the appeal in the following manner. The order of the trial court is dated, trial court in I number so-and-so, in OS number so-and-so is set aside. And
Not to alienate is also there.
Huh?
Not to alienate is also there. That remains
Huh.
as it is.
Is modified. The order of the trial court is modified. And the defendant is only permitted to lease, rent the premises, number one. Number two, she shall, the particulars, with regard to the lease and the lease oblique rent and the rental that she is running of it, it should be properly accounted and shall be placed before the trial
Trial
court
court will
from time to time.
And
Accordingly disposed of.
Cell number 41, Raghavendra C. for appellant, Nanda Kumar TM.
Yes.
Just may kindly recollect. My lord, I have filed two applications for condonation of delay yesterday in the office.
How much is the delay?
6 days, my lord.
Hmm.
6 days. Filed it in the office, not been put up.
Even that also,
Lordships.
you don't appear before the court, number one. Next, even for filing a petition also, when is this matter adjourned? When is this matter? And the last occasion, when did it came?
My lord, on Saturday, my lords, due to paucity of time, it was now urgent to today.
Yes. Hmm. Let's hear him.
Only for a moment, my lords.
Hmm.
Your lordship may kindly, the caveat copy is available on the file.
Hmm.
What the affidavit, the person who is coming before this court is filing affidavit is one Mr. Jagdish. For a moment,
Hmm.
Wakalat may be kindly looked.
Give that, give that.
The caveat petition may be kindly looked into. That should be in the file. What signature he had affixed, the same name was reflected in the cause list. And he should have come and filed the affidavit before this court. One Jagdish is coming and filing affidavit.
He's also on Wakalat, my lord.
Your lordship may kindly see the Wakalat. When your lordship may kindly pursue the Wakalat, my lord. Nandakumar TH, the signature is Nandakumar TM. The office had noted the name of Nandakumar TM. Even the Jagdish signatures are coming later. The pen is handwriting is different. Now Jagdish is coming and filing affidavit. Nandakumar should have come and filed the affidavit. That is a case where Nandakumar's name TH has been reflected, not TM was reflected. If Nandakumar should come and file affidavit, where is Nandakumar? There's a question which I'll have to post for myself. Where is Nandakumar? Nandakumar should come and file a affidavit because that is the case is that the cause list name is Nandakumar is perfect. Only TH and TM was a difference. Let him come and file affidavit. Why Jagdish is coming and filing affidavit? And his phone number, since then till now, this phone number is not in existence. The phone number which is noted in the Wakalat. Because only I'm stating this before your lordships. The appellant, the plaintiff before civil court has adopted all these statics in all the civil cases, filed various civil cases for have different lawyers, and those lawyers would not, their address would not be in existence. What all cases, which are?
Phone number is this?
Lord, it was written by my clerk, which is a wrong number. It does not pertain to my number, Lord.
Why he has written?
Lord, instead of 974, he has
No,
written
what is
947.
this tactics? You file a caveat, you give your number, and you tell that the
Lord,
advocate
it
has
was
given
not
some-
sent to my phone number, my lord, nor it was sent to my address mentioned herein.
They've sent, then the
It
number
was-
itself is not existing.
Lord, it was sent to my email address.
No. Why
Which-
should
which
a
is not there
phone
in
number?
Wakalat.
Why should a phone number?
Lord, it's-
That's why he's saying that.
Lord,
No,
that-
this is not existing.
No, not no, he's admitting that. It's,
Sir, I'm
it's wrong. How
admitting
can
that.
Why-
wrong
I
number?
cannot even deny that.
How-
I
why
certainly cannot deny that. Lord.
Why should it be given?
Lord, it was a mistake on part of my clerk. A mistake on part of my clerk, my lord. That cannot be subject.
No, everything can't be a mistake.
Lord, this is only the mistake that's on part of my clerk.
Then
And I
Nandakumar,
fail to
Nandakumar
understand,
is
Lord.
the advocate, like TM or TH has filed the wakalat. Where is he?
Lord, he's present, my lord. He's also here.
Has he filed the affidavit or whatever it is?
Lord, he has filed, Lord, it is the same office, my lord, on that day on filing the affidavit. Due to some urgency, he was not there. Lord, instead, my lord, the person who was there on the wakalat was also my colleague. Lord, he has filed it.
No,
Lordship may
what-
kindly, my lord,
No.
Lordship may kindly bear with me for 1 minute. Lord.
Yes.
Lord, can a notice or a summons or a copy be served through email address which is not in existence and submit before the court stating that, no, I've already served the copy. He is not present. Therefore, please kindly hear the matter, my lord. That's my one.
Is
respectful
it not,
submission.
is it right on your part to file a wakalat, which the name cannot be understood, the number cannot be found,
Lord, that's a part, Lord, that's a
First of
mis-
all, the first you have to
Lord,
answer
Lord,
that.
that's a
then to
mistake.
Go further.
Lord, that's a mistake on my clerk, Lord. Nevertheless, Lord, the address is correct. It's still in existence. It was always in existence from 10 years. The address is correct. You ought to have sent a notice.
Let's not go into this. Let's
Obliged.
deal with that,
Right.
so that, yes. Please come to the order. What is wrong with the order passed by this court?
Lord, I need to file my, his
No, no,
written
no.
statement. His written statement, which is not a part of the document, because
So you can pass on it.
Lord, I'll file my statement of objection. I will only be permitted to file my statement of objection when this order is recalled. That's my.
No, that will not be recalled. We will
Dehorse
hear
this
it at
order.
a point.
Dehorse this order, my lord. If my lords would say, yes, I can file my statement of objection, I would be definitely filing. this
Objections you will file.
For the
Court-
MFA, my
no,
lord.
I am looking at the
Please.
order that is passed by the trial court.
Certainly, my
And
lord.
basing on that, this order is
Certainly,
passed.
please.
What objections are required in this?
Lord, he has not filed.
I have
Lord-
not looked into any other document except the documents that are there.
Lord,
before
in the
trial
MFA
court.
copy, in the memorandum of appeal, his written statement is not forthcoming, which I'll have to place it on record because
that is
So kept it by this time.
is there before
Lord,
the court.
I will not be permitted to file that, my lord.
That is there before the
Fine,
court,
no,
my lord.
you-
I had given it to
Pass
the
on to
court.
the court.
Lord, it's not a part of the document.
No, it was gone to the court.
ಇಲ್ಲ, ನನ್ಗೆ ಕೊಟ್ಟಿರೋದಿಲ್ಲ.
It is gone to the court. It is there in the
How
court.
is telling that?
No, it is there in the court. Your Lordship
How is
pursued all
telling?
these things, only the order was passed. It was there,
How is telling?
it was there before the court.
Lord,
You can argue.
Lord, I'm instructed to engage a senior, my lord, to that effect, Therefore, I request your lordship to say, dehorse this order, dehorse the recalling order. If my lords permit me to file, my lord, it's already ready, my lord. I'll only need to get the signatures. I'll file it tomorrow or Monday. Lordship may have it on Monday. I'll let us my arguments, my lord.
Let there not be any order. Let him come and argue on Monday, my lord. Because immediately, very shocking. Just showed you.
No. Every.
His father
the-
had gone an interim order
the
after 10 days.
client- The client, the
Not even a
respondent-
single rupees
one
transferred
minute,
to
the
my account
respondent,
out of the 15.
The respondent, for any of the lapses or any, if the court finds that it's been,
Yes.
they've been playing with the process and this is how they have been taking advantage of anything, exemplary cost,
Obliged.
turning into lakhs will be imposed,
Monday.
not
Yes,
one
may I
lakh.
also please kindly note, out of 15 crore, not even a single rupee is transferred to my account till date.
Yes, we will see that. Yes, next, pose this matter on Tuesday. This matter on Tuesday on the top of the list.
Obliged.
I maybe have
Still number,
serving the liberty to file the statement of objection.
No, you can come, you can give it to the court, no liberty. On that day, you can pass on.
Great.
Yes.
still number 42,
For the appellant in this matter.
okay,
There is a delay of 98 days in filing this.
Notice to respondents,
still number
post after service of notice. Yes,
43. Pradeep Kumar,
no representation, post after vacation on 11th of November. Yes,
still number 44. Azimuddin,
let's see some IA 1 of 24 for paper publication, will order. Nothing is written. No representation for the petitioner. Pose this matter on 12th of November. Next,
still number 45. It is Rajavani.
Appear for petition. Kindly allow IM for paper publication.
the application is filed. Take out notice wherever substituted service on the respondent in Prajavani, Kannada, Delhi, Mysore edition. Accordingly, IA is allowed and the petition is permitted to take out notice and on so and so, on which date?
In 10, hearing on 24/10.
Yes. Yes,
46. BK Sampath Kumar, Suraj Sampath,
Appealing for the petition. Lord Senior is upon his legs in another court.
My lord, there is an interim order prevailing in this matter from 2021, my lord. I have filed a petition under 13(1)(a) against my wife, and that has been stayed from 2021, August 19th.
In this case,
Please, my lord.
how can it be?
Lord, there is a stay on proceedings granted, my lord.
Why?
I have filed a vacating stay application, my lord, that is
Lords, they had
pending
filed
for
an
your
IA
lordship's
under
consideration.
section
What is an order? That is, what is the order passed by the court on maintenance?
Please, my lord, it is dated 17th September 2021, my lord, wherein the interim order was granted staying the proceedings in MC number 6930 of 2000.
We'll vacate that order. Why should the proceedings in the MC be
My
stayed?
my lord, there has
You are
been,
for the wife or respondent?
I'm the wife, my lord.
my lord, I am
Main-
the husband.
Maintenance is not paid.
My lord, I am paying up to
Challenge,
date
they had filed an
maintenance.
IA under the trial code, my lords, under section 24, seeking for an interim compensation of rupees 1 lakh. So there only 15,000 was granted. In regards to that, we had challenged that order and get.
In that
My lord, I'll
case,
just
why
brief-
should the proceedings be stayed?
My lord, I'll just
But
brief your
regarding that-
lordship in
No,
2
no,
minutes.
Lords, regarding that, some senior,
No.
it's a short
No,
password
senior.
also.
My lord, I have been making payment of interim maintenance from the institution of the case till date, up to date, my lord. Even this month I have
In
transferred.
a
rupees
case of
15,000.
enhancement, why should the proceedings be stayed? What
Please,
purpose?
my lord, kindly vacate the interim order, at least let me be,
Short passover, senior will come make submissions regarding that itself.
my lord, there is nothing to be
Tell
submitted.
your
but
senior
we
that
are-
interim order will be
But it's
we are
vacated.
paying
but
the
we-
maintenance, my lord. It is up to
If
date.
both of you want to argue, then argue.
My apologies, my lord.
I will leave, my lord.
Pass over, let your senior come. Tell the senior at the end of the list, I'll vacate the interim order and let the court proceed with it.
Please,
If you
my lord.
want enhancement, it will be decided by the court. Why should the proceedings be stayed?
Please, my lord.
Yes.
Oblige.
Cell number 47, Arun Govindraj.
I would kindly request password that senior is reaching in 5 minutes, my lord. There's an urgency in the matter.
No, what is the time?
I'm-
How can
I
a senior reach, you ask for 5 minutes at 4:34.
No, he's coming from civil court, my lord. I'm requesting password.
Court can't help it if he comes from civil court or criminal
Have
court.
it on Tuesday, my lord.
No, my lord, because 13th of school fees, last date is there, my lord. Request
What
for
to do
urgency.
when you
I
people are
request
not?
password, my lord.
Yes, yes, next matter call.
Cell number 48,
I'm for the respondent wife in this matter, my lord. On the last hearing, the lordship has directed that the child be assessed in Nimans. Still, the proceedings are going on. They need another 3 weeks.
Let's
For
see
the-
the.
Now they've been called on the 26th and 28th.
Hmm. When they are, next, when is the appointment?
26th and then 28th. And then they need another 7 sessions with the child because they're assessing the child for IQ, EQ, analogy, and also for autistic, any exhibits of autism.
Yes.
Please, no objection to that proceeding.
Then,
only If his usual visitation is on Saturday, lordship, if lordship's all right, on first it could be taken up so that what happens on those 2 dates, they could report.
No, it says 26,
want
28.
further-
After that,
Another-
there are 7 sessions.
Another 3 weeks is needed, my lord. As
Another
per
3
the-
weeks. That's what they say.
Please, your lordship,
So,
until such
like,
time.
it is submitted by the land counts for the respondent mother that on 26th and 28th also they're having sessions before the Nimhans, and further another 7 sessions are required. Pose this matter, once a report is placed by the Nimhans. Therefore, in the meantime, what about the visitation?
We have
In the
no
mean-
objections in the mall, my lord. As per what is done the last time. In the mall, he may be permitted to meet, my lord.
Your lordship, it's undoing what your lordship's earlier order is. Last week also, we considered only.
Till the case is listed, the father can exercise the visitation on Saturday between 1 PM to 5 PM at Meenakshi Mall.
Correct. The order before that, your lordship had passed, we had even reported it. Child's very happy at home, eating, feeding, displaying everything. Last week.
Like we are at this, with the verge of that assessment, till the next date of hearing on every Saturday between 1 PM to 5 PM. The father can exercise the visitation at Meenakshi Mall and the mother shall bring their daughter to the mall.
Your lordship, the Dashera vacation, your lordship.
until the report is placed, my lord. We don't have any objections until the
On
report
every
is
Saturday until the report is
Please,
placed.
Published.
the child's birthday is on 7th, Your Lordship, 7th of October.
7th?
7th
On
October.
7th October.
And
Saturday
happens to
1
be-
to 1 to 5 also he may meet, my lord. I've spoken to him. 1 to 5 he may meet the child on that day. We'll bring the child to the
seventh-
Your-
on
we-
either
on
to
4th
Meenakshi Mall or Vega Mall, my lord.
Your Lordship, on 4th is his birthday and on 7th is the child's birthday. Those 2
7th,
days.
1st, 7th October. Same from, what did you say? 10 o'clock, 11th?
1 to 5, same orders as 1 to 5
to
at
5
Meenakshi
in the
Mall
same- in the
or
same-
Vega Mall, my lord.
And when is his birthday?
On 4th, Your Lordship,
4th of?
October.
Uh-huh.
And
4th of
7th is
October
her
is
birthday.
also a holiday. Same times on 4th of October on the birthday of the father. 7th of October is a birthday of the girl.
Please. Your Lordship, might I request the matter be taken up as part heard? Reason being, Your Lordship has met the child, spent extensive time. Yeah, I understand it's a
Next,
burden, but
then what will happen for the next 2 months? I'm going to Dharwad.
Your Lordship, online, we will apprise Your Lordship.
I think every day I have to appear online with all these partners.
Your Lordship, we shall not unnecessarily.
Lordship,
burden
once the report is placed, we'll come before your lordship.
Please, please. Until
40
such time, the this
47.
will continue.
The partnered.
Obliged.
Cell number 49 urgent.
48.
Obliged, my lord.
Smart. Yes.
49 urgent, 50. Rajesh, KS.
After the report is placed. 50, no representation for the petitioner. Was this matter on 19th of November? Yes.
Pass over in list number. List number 2. I mean. List number 2, cell number 1. P. Sheshgiri Rao, MP Chandrachudha.
Where is he? He wants to argue on the maintainability. Is it the case?
Not a question of maintenance. Defendant is before this honorable court. There's been an injunction which has been granted in a suit.
No, where is the counsel? I'm saying, Mr. M.B. Chandrachudha. This court case has undergone adjournments on several, at least 7. Okay, again, a request is made for the adjournment to pay to the advocate. The adjournment is granted. Both this matter on to under the caption dismissal. The appeal shall stand dismissed without further reference to the court. What had happened? Is
The
it paid?
costs have been.
Yes.
Now, my lords, it was a case where my lords, an injunction has been granted.
You
against-
have an interim order in your favor.
But it's in the nature of a status quo now. So it has to be in the nature of a status quo. Now, my lords, basically what has happened, my lords, is this was a land, my lords, which fell within the ambit of a grant land, my lords, for which the PTCL Act would apply. My lords, the grantee, my lords, sold the land in contravention of the terms of the grant. My lords, which led to initiation of forfeiture proceedings under the.
Shall we have it on Monday? Tuesday, he's not there. Counsel for the respondent.
Very well.
No
Not under
representation
this
for the.
head, that is what.
It will be. You are present now.
Yes.
Delete from the caption for dismissal. As per the order passed for this court, it is submitted that they have already paid costs of rupees 2,000. Was this matter after vacation on 12th of November?
Is it possible on Tuesday? My lords? One
Tuesday. Post on Tuesday. If it is, we'll do. Otherwise, it will be adjourned.
Please.
Tuesday. Yes.
Cell number 2. Rajeshwara PN.
Give that. On 3/6/2024, there was no representation. The matter was directly to be listed for dismissal on 5/6/2024. And on 5/6/2024, at the request of the petitioner, again, the matter is deleted from the caption for dismissal. Then on 19/8/2024, there is no representation on behalf of the parties. And the matter was directed to be listed on 24/9/2024. Again, on 24/9/2024, as there was no representation on behalf of the petitioner, The matter is directed to be listed for dismissal today. Today also, there is no representation on behalf of the petitioner. It appears that he is not interested to pursue the matter. Dismiss for non-prosecution. Yes,
Mallikarjun.
For the petition.
Shiva.
yes.
Lords, if my lords recollect, on the last occasion on 10th of September, I had paid 3 lakh via DD. I was directed to pay the remaining arrears of maintenance. I have questioned the order of maintenance, interim order of maintenance granted, my lords, by the trial court. 50,000 is granted, 30,000, my lords had said pay the arrears to an extent of 30,000 from the date of the petition, my lords. I've paid 3, remaining is 6.8 lakh. Since the petitioner had paid in the very same month, September month, he is unable to gather the funds, my lords. 6.8 is a very large sum, my lords. He may be permitted another 2 weeks, my lords. He'll do the needful. In the meantime, my lords,
We'll post this matter on Tuesday.
my lords,
Please understand,
no,
by that
I'm-
time, please understand what the court is saying. By that time, whatever you're saying, let it be filed in the form of an undertaking before this court
Hmm.
by your counsel that's indicating 2 weeks, a particular day, that the remaining amount would be paid.
some time is what I was asking, my lords. My lords, my
No,
difficulty is
If
that
not 2 weeks, take 4 weeks. In 2
I-
weeks, how much amount?
very well,
In
my
4
lords.
weeks, how much amount? Let it be an undertaking by way of an affidavit.
Very well, my lords. My difficulty is that I'm not there in station on Monday and Tuesday, my lords. Can it be had Friday, my lords, day after tomorrow, my lords?
Friday court is not there.
It's
Milords,
on 14th then, my lords.
petitioner is saying that every month he is spending 1,20,000 on his expense. If he had kept some money during this time also, he could have paid the wife
Yes,
and the
you
child.
file an affidavit.
Yes, my lords. My lords, I must also indicate there are 6 cases pending between the parties. 4 initiated by the respondent wife, 2 initiated by the petitioner husband. The 2 which are initiated by the petitioner husband are that of, one is GNWC for child custody and the other one is restitution of conjugal rights, my lords. Both are pending. I must also indicate, my lords, there is a Domestic Violence Act case which is invoked against the petitioner husband. The prayers made there are 1.36 crores as monetary relief, 1 lakh
And you leave all
99,000
that. You
monthly.
file an affidavit by
I
Friday. If
understand,
you're
my lords.
not there,
There's
file
some-
an affidavit by Friday. We'll have it on Tuesday.
My lords, I'm not available on Monday and Tuesday. I'm sorry about that, my lords. Kindly have it on 15th, my lords, the very first day of reopening in that case, my lords.
Then file it on Friday. The matter will be listed on before some other court. An order will be passed. I'll record that.
It's on 15th.
You're there on Friday. That's what you're saying.
Friday, I'm there, my lords.
We'll post this matter on Friday. Let the matter go before the other court.
My lords, the other issue would be that the petitioner is in Dubai. He's the resident of Dubai.
he's on
Right from
bail.
Please
2007.
understand, let him complete. Yes.
Right from 2007, he's been working in Dubai. The marriage is registered here in Bangalore, therefore the jurisdiction is here and it is invoked. My issue would be that to get an affidavit from the party by Friday, again, that may become a problem. Let's kindly
He
have it
was
on.
here on the last occasion.
No, my lords, he wasn't. He wasn't.
He was there in the court.
No, my lords, he wasn't. He's been working in Dubai from 2007. In 2021, his
So
employment.
he'll be happily sit there, engage an advocate and will watch the show from Dubai.
Certainly not, my lord. Certainly
I
not.
think last occasion we had enough discussion. I think no more intelligence
Kindly
is
have
not
it on
required.
15th. Kindly have
More
it on
intelligence is
15th.
not required from this court.
Kindly have it on 15th is what I'm requesting, my lords. 15th, my lords, I'm going to get the affidavit and place it on.
Milords, the petitioner is not getting any monetary. He has been dragging like this forever.
The order is dated June 2023, my lords. Since then, 3
I
lakh.
think you can read what is the order on for 24/9. So what is the purpose of again making some submissions today, saying that you want time? Court is specifically said on that day. Or that you think that the court has forgotten what has happened on that day?
Certainly not, my lords. I bow down to the order passed on 10/9, my lords. My difficulty is that he is a freelance music teacher. He is unable to gather 6,80,000 in 15 days, my
So
lords.
what we do is let them have the execution, let the warrants be issued, let whatever they want to
Lords,
do.
they've
do.
already
We will dismiss
initiated.
it. We'll
Milords,
dismiss your application.
He has
Then,
money to
my-
spend on his
Then the
expense.
matter may be heard on merits, my lords. Then the matter may be
It's
heard
already
on.
heard on merits, Milord. He
That's why we'll
says
dismiss it. We'll dismiss this
finally it may
petition.
be dismissed, confirming the lower court order, Milord.
In
My
spite
lords,
of.
I have two
Confirming
submissions.
the lower
I
court
have
order.
2 submissions to make.
Yes.
In the assets and liabilities, the respondent wife has admitted to being employed and getting 61,000 as monthly salary, whereas the petitioner husband is earning 91,000. The trial court has granted an interim maintenance of 50,000 per month. My lords, my request is that 50,000 is on the higher side, because 61,000 is her salary and 50,000 from the petitioner's side. And the petitioner is having.
First of all, you have no interim order from this court. When you're not complying with the orders passed by this court, passed by the trial court, why should there be an adjudication on merits?
My lords, I am trying my best to pay the arrears, my lords. 2023 June is the impugned order.
Conveniently, you've been
My lords,
dragging on
let
this
me,
matter. How many
Kindly-
times-
just a
kindly the
moment.
petition may
June
be
June
dismissed
20
confirming the
June
trial court order.
2023 is the impugned order passed. From June 2023 till this days, 14 months have been passed. 3,50,000 is paid. The amount from 2021, the date of their application, till the date of the order is what is remaining from my side. Therefore, this request, my lords.
How many times you'll make the request? How many times the court will?
He's not in a good shape, financial position.
He said that this would be the appropriate amount. Accordingly, court said only pay on that, not as per the order passed by the trial court.
Certainly, my lords, but then he's not unable to gather a large amount of 6.8 lakh in 15 days, my lords. That is why I'm before my lords seeking short indulgence, my lords. Kindly have it on 15. By then I'll take
Lords, how
appropriate
the wife of
instructions.
the children
If the,
live, my
if the
lords.
affidavit is to
From
be, if the
2021,
affidavit is to be
until
placed on
this
record,
honorable
I will
court
place it,
passed the
my lords.
orders, they had not paid even 10,000, not even 100 rupees. my lords.
So how many
Kindly it
orders?
may be dismissed confirming the trial court order, my lords. That is my humble request. He has not even filed his assets and liability affidavit also in the trial court.
That is
And
on
according to
record.
Rajneesh versus Neha, whenever the respondent does not file the affidavit, it may be taken.
Is it correct that your income of the respondent is 60,000?
60,000, but including that all that deductions all will come inside that. And then an amount will come in which she has no shelter also. She is living in the church premises under the mercy of the church with 2 children. She is giving very good education for the 2 children, my lords.
I would
She's,
dispute
teaching
that
the-
submission,
she's
my lords,
teaching the
because in
good-
the domestic
what is
violence
his
petition,
responsibility?
she has given a
Domestic
residential
violence,
address.
There also she has
The
not got
residential
any,
address which
she
is
has
wrong.
not filed
I'm
any
sorry.
application in domestic violence also, my lords.
What the
I'm sorry.
advocates are not understanding, from morning to evening, if advocates are fighting like how the parties are fighting, it's very difficult for the court to